All right, recording is started and you can take it away.
Thank you. All right. Good evening, everyone. The reason for our law practice being so hyper-focused in this area is my brother Mitch. And so I always like to start with him. As you can see there, he is doing some shredding at our office. He comes in once every week or two. Hey, excuse me. Excuse me. Do some shredding. Big thing there is to make sure what he's shredding, that he keeps to the box that we give him and not other things. But he has his worker, one of his personal support workers, that is working with him in his group home. His DSP staff, they come and come with him, and then they take him to the rest of the day, whatever he's doing, sport employment or day program. And then back to his home. He lives in a group home run by Clearbrook in Mount Prospect. So that's that's Mitch. That's who inspired our practice. All right, a little bit about being a sibling. I think it's so important when I have the opportunity to speak to parents as well as even professionals that work with children with IDD. It's just so important to talk about the importance of siblings. Being a sibling helps put things in perspective in life, just like it helps parents put things in perspective in life sometimes, but it's different than the parent perspective. We either from a very early age, or if we're younger, like myself, than our sibling with disabilities, we don't even know what it's like to not have a sibling with significant disabilities. And so it really shapes our life experience in so many ways. It affects the friends we choose to have and not have. It affects the what we would choose in terms of the what people do in terms of their academics. We've seen that a lot of times the average sibling is actually can be an overachiever. This is obviously gross generalization. There are kind of different archetypes of siblings. Actually, some are overachievers, some actually struggle in many ways. But in some way, some way, shape, or form, it really impacts them in a lot of different ways. They tend to be more mature than their peers. That's pretty much across the board. Again, not every child, but the vast majority we find are more mature than their peers because they're dealing with some pretty big topics, pretty big issues at a young age, and take on some responsibilities that their peers may not. Vacations were an adventure for with my brother, and so he would maybe have a meltdown, and it would be difficult, and we'd have to need a vacation after that vacation. That certainly happened many times growing up. One of the things we talk about with siblings, it's important to validate their feelings and emotions as siblings. They may feel embarrassed by their sibling, who is maybe having a tantrum. It looks like to other people maybe they're a little old, quote unquote, old to be having that kind of a tantrum in that scenario. Like when we have trips to the grocery store or store in general, and maybe that happens. And people may make comments or may give looks, or maybe just even if everyone kind of gets it because it's 2025 and people have a lot more awareness now, it doesn't mean that the sibling doesn't get embarrassed, right? And they may even feel complex emotions. They may feel guilty for feeling embarrassed, okay? And that's okay. And that's really important that we validate that those emotions can all be there, and they're legitimate emotions and they're normal emotions. And they can feel resentful of the amount of attention their sibling gets, but also feel guilty for feeling that resentment. They can feel protective of their sibling, but also jealous of their sibling. And that's okay. And we want to make sure that we validate what those feelings are. Um, One thing that I do emphasize is important with parents is to take opportunities to have one-on-one interaction with the other kids. For big thing my parents did that stood out was when my brother had an opportunity to go to an overnight camp with a one-on-one aide, and when he did that for that, what was like a 1 week program, and when he did that, my parents took my sister and I to on a trip. We went to California, went to New York a different time. It was 2 different summers this happened, and it was an opportunity for my sister and I to be the center of attention, to be whatever we want to do. It wasn't always dictated by what would work best for Mitch. And so it's really important when you have opportunities. That's kind of an extreme one, a vacation, but maybe it's just for a few hours. Maybe it's an outing. Maybe it's going to a game. Maybe it's going to just outing somewhere where it's just one parent. If it's both parents, great, even better. But even one parent, where they can have that tension where it's not about their sibling all the time. And then the understanding of future responsibilities is something that really unites siblings. Is that we know that it is very likely that our brother or sister is going to outlive our parents, and we're going to have to be there for them in some capacity. And we don't quite know exactly what that might be yet. Maybe it's as their guardian, maybe as their trustees. We'll talk about. We don't know necessarily, but we know we're going to have to be there to some extent. And a lot of times what we find is that siblings have some really big responsibilities they expect to have, and that maybe not what the parents expect. And so it's really important that from a very early age, we have the open dialogue about what does this really look like? Maybe they think, well, that means my sibling's going to live with me the rest of my life. But as they get older, when they're 10, 11, 12 years old, they're thinking about this stuff. Have an open dialogue that you can discuss this, that's not what our intention is that we fully expect, in many cases, we fully expect that you're going to be involved in your sibling's life and you're going to be making sure they're being taken care of and have the right supports they need, but they're not necessarily moving in with you, right? And what that might look like. So, one of the things we talk about is that the parents' planning is super important for that child with special needs, but it's almost as important, if not maybe even more important, for the other kids. Because if the parents don't plan, that means that crisis is going to fall into the lap of the other kids to figure it out after the fact. And that's not a good situation. We want to set up the child who has disabilities for success. And we also want to set up the other kids, if there are other kids, for success as well and their role with that future. So I'm past president of SIBS, supporting other brothers and sisters, Illinois chapter of a national organization called the SLN, Sibling Leadership Network. We have a national organization with state chapters. We have, you can see our website, okay, sibsnarc.org, the national organization. We have, for adult Sibs, we do bar nights and barbecues, and people post about, on our social media platform, they'll post about they're getting married and what role their sibling had in the wedding, and they're worried about what role their sibling has in the wedding, and they want to make sure that they are part of the wedding, but also not distracting from their day, their special day. For once in their life, they can have a day that's not necessarily focused and centered around their sibling. They can feel a little resentment about that for sure. And that's obviously, again, their whole feeling, but also they want them to be there and they want to be a part of it. So how do they balance those emotions, those feelings? It's really nice to have other siblings who get it and can share that. They're raising children and what's interactions that their child has with their aunt or uncle and things that can come up. And it's just really nice to have that network of people just to reach out to and connect with. If you want more information about this stuff, about sibling groups, adult sibling groups, SIB shops for younger siblings, we help facilitate, the SIBS organization helps facilitate training for SIB shops, fund social activities for brothers and sisters that have sibling disabilities. So these started at age 7. So if you have other kids who are starting about age 7, they can attend SIB shops. They're throughout the state, throughout the world, actually. It's an international program. They are age bracketed, so it's like 7 and 8-year-olds have a program, 8 and 9-year-olds another one, 9 and 10-year-olds another one, 11, 12-year-olds, and so forth. So it's a way they could meet their peers that have this similar life experience, and they can just do fun social activities. It's like they're just there and talk about their sibling all day. That's not the point of it. Is they can meet other siblings and have natural, organic interaction with others who are just, it's just kind of, everyone just knows they have that connection, but it doesn't have to be talking about that connection. So I highly encourage them to at least try it and see if it's helpful. So you'll see this information request form. It was emailed out to you, I believe, already. So you should have it. All you have to do is, on the PDF, you just click, the checkbox, and then you can fill in your information. It's fill, fill in the form on the PDF, and then send it to us. Or if you're having trouble with the technology, just print it off and just write in your name, email address. We'll send you the information that you asked for. All right. So, how much when we talk about planning for the future, okay, and that's obviously the topic of today's discussion, planning for the future of someone who has significant disabilities, how much do they need and where's the money going to come from? Okay. When we talk about planning for college education, we can come up with a ridiculous number, maybe. I was told for my daughter, who's 7.5, it would cost something like $800,000 to send her to 4 years at my alma mater, Northwestern, which is ridiculous. But that said, you come up with a number based on what the current inflation and everything is. But when we talk about someone with, like my brother, we're talking about not in 10 years. We're talking about 50, 60, 70 years. What government benefit programs will even exist, let alone what they qualify for, forgetting inflation, return on investment kinds of things, okay? So we have government benefits as our base, our wise part. We don't do things that are interfere with, jeopardize, or could reduce those government benefits. And we'll talk about what those benefits are, which is important to plan for now, so they'll be available there when they are a little bit older. But inheritances, we have to make sure don't affect things. So to avoid this problem where inheritances mess up government benefits, we need a special needs trust. There's actually two kinds. We'll talk about it. And they can still work. Okay, my brother works in the community with a job coach a few days a week. Half the time the job coach does a job he watches. Sometimes he participates more in it. And there's obviously a wide range. There's individuals who are working part-time, individuals actually, you have clients, of course, who are working full-time, and we can talk about it affects benefits, etc. But in the most cases, we don't have work earnings that are so much that they kind of make this whole pyramid topple over, right? So as long as they can earn some money within certain limitations and have their inheritance in a special needs trust and have their base foundation of government benefits. So let's talk about those government benefits, because that's what we're actually protecting. And I know that most of the families here, kids are young, preschool age, maybe kindergarten, first grade, second grade, early on. But there's stuff we need to do now to plan for what's going to happen in the future. The first program is SSI, Supplemental Security Income. Social Security is somebody who doesn't have a work record and who's disabled. Now, they have an income and an asset test, and prior to age 18, they look at parents' assets and income. So in the vast majority of cases, a child's not going to qualify. Thank God, because if they do qualify, it means that the family is really struggling financially, because the income and assets are very, very restrictive. Now, it's $2,000 asset test for an individual, slightly more for family, but it's basically very, very low numbers, restrictions. So for the vast majority of people, not going to be having until 18. But once they're 18, they can apply for SSI based on their own asset and income test. Asset test is $2,000. It hasn't changed since the 1970s. They propose every few years to increase it, and it never goes anywhere. That said, so $2,000 asset test, they do look back 3 years. So at 18, if you apply for benefits, but they had money in a custodial account that you thought you fixed by getting rid of it when they were 16, you're out of luck. They're gonna count that money. Okay. So when we talk about planning early, we gotta not just for 18, we gotta plan for the look back period, which is 3 years, currently 15. And for certain programs, it's actually 5 years. So if we want to be super safe and conservative, we actually want to make sure that everything's out of their name before they turn 13. Okay. All right. So hopefully that'll be the case. And since we're talking to very families with young children, we can do it now. Make sure nothing goes in their name, no assets in their name. We don't have grandparents buying bonds. We don't have custodial accounts being set up and money being put in them being put in that account for them from grandparents or the parents. We can do it now. Make sure that that's cleared up now, because we're outside of any look back period at this moment. The income test is the disability test. Okay. By the way, if you have some money in their name and you did clear out that money, and I didn't tell you to do this, but you did clear it out because you're outside the look back period. One thing that would not be a good idea would be when your child turns 18 to tell Social Security that you had money when they were 7 years old and you cleared it out. Okay. Because it's a look back period. It's not that if you voluntarily tell them they had money in their name earlier, they could potentially still give you a hard time. It's a look back period of what they're able to look back at. So they can look back 3 years. Worst case scenario, make it look 5 years. If you did something when they were way before that, there's really nothing for them to be able to see, and that's how the law works. But if you voluntarily tell them they have more money in their name, you can cause yourself problems. So just that would be a scenario that would probably not be good. All right, now, so make sure before any look back period, maybe that I would hope that all the assets would be cleared out. They have nothing in their name. Then we get to the income test. That's the disability test. At 18 years old, they would look and say, do you have the ability to go out and get a job and earn $1,620 gross work earnings a month? Okay, this is not like unemployment compensation. They're not going to say, prove to me you couldn't get a job at 18, because they're going to be in the transition program at school almost certainly. Instead, what they're saying is, could they hypothetically get a job? And they look at diagnoses. Interestingly, Down syndrome is not on there, but autism is. It's kind of a weird thing. What's listening level impairment, what isn't? But you can often qualify under a catch-all definition of intellectual disability or developmental disability. And then they have functional limitations. Just because of a diagnosis, does that mean that they can't go out and get a job and earn 1620 gross earnings a month in today's dollars, adjusted for inflation? Look at all these different factors. Why? Okay. All right. So in today's dollars, people get a check for $967 a month. Okay. Obviously, for all of you, we're talking about at least a decade from now, maybe more. So it's going to be a lot, with inflation, it should be $1,100, $1,200 a month, maybe more. I don't know. By the time we're looking at this, okay? But okay, they got SSI, whatever that amount is in today's dollars, it's $967. There's a whole thing if the parents let them live at home rent free, then they knock you down by a third. So we could, that's kind of, again, this is stuff, details for when they're closer to 18. But just to be aware of, there's a whole thing that they can get SSI reduced if they're living rent free. If they're working in the school when they're still in this transition years until they age out of special ed services, it doesn't affect their benefits. But once they're done with school and age out of special ed services, after $85 a month, their SSI gets reduced again for work earnings. Okay, but what about SSDI? That's Social Security Disability Insurance, and it's very important that we get them SSI. Okay, because if we get them SSI, the rest of the four quadrants here open up to us. SSDI is Social Security Disability Insurance. Social Security is someone who either has a work record and is disabled, or there's one other way we'll talk about they can get it. When you talk about disability insurance on their own record, they could build their own quarters. Okay, for example, we've had a number of clients who had either they or their sibling or the grandparent, someone had, like the aunt or uncle of the child or grandparent, had a business, okay? And they came up with a job they can do, and they put them on payroll and paid them just the amount they need to get in their quarters, okay? Social Security quarters, kind of a complicated concept. It's not a 3-month period, it's a calendar year. You can earn up to 4 quarters in a calendar year. If they get their quarters before age 24, 6 quarters, what they need, they'll get a small SSDI check. And so that's why they get Social Security on their own record. Dollar for dollar reduction of SSI if they do that. So they're actually no better cash-wise. They're no better off by getting that check and paying into FICA and getting their SSDI check because they have enough quarters. But it gets them their Medicare card 2 years later. So for a lot of our families, think, hey, you know what? I want to have peace of mind the kid has Medicare. So what I'm going to do is I'm going to get them their quarters. I'm going to make sure they have no 4 quarters. Not too much that they might not be deemed disabled anymore, but enough to get them their quarters. And then once they have them, if they have SSI already at that point, they automatically get SSDI, and then 2 years later, they'll get their Medicare card. And then they have Medicare the rest of their life, okay? Now, that's not the way my brother got it, okay? My brother got it a different way. He is what's called a DAC, Disabled Adult Child, or receives CDB, Child Disability Benefit Status. The way it works is this. Oh, excuse me. So long as the SSI is received before 22, technically it's more complicated than that, but if they receive SSI before age 22, that's enough to qualify them for sure. So if they receive SSI before 22, that's why we want to apply right at 18. Actually, careful on that. Do not apply on their birthday. They'll get denied. You have to apply in the first day of the calendar month after they've already turned 18. Okay? All right, it's a technicality there. All right, now so you do that. They get their SSI well before the 22. Then when a parent takes Social Security retirement, disability, or passes away, hopefully this retires, they get to go on the parent's Social Security record and get more money based on what the parents pay into the system. Okay? Hopefully, so we say parents file Social Security retirement, they get to go on the parent's record. The amount they get is based on the parent's Social Security record. So, and it's an add-on. It's not like it takes away from the parent's record. So, for example, let's say that if we had let's say we had a parent who was a doctor and had a max record. They hit that max amount each year, or Social Security stops taking out Social Security tax. So they had a max record of 35 years. Currently, that means that at full retirement age, currently age 67, that the parent would get about $4,200 a month, something like that. The child would be entitled to an additional check separate to them for them of $2,100 a month at that point. Okay, so the parent files Social Security, the child gets it. The amount that the child gets is actually based on 50% of the so-called age 67 or primary insurance amount, full retirement age amount. So even if the parent takes it early at 62, while the parent is penalized for taking it early, the child is not. Okay. Same thing goes the other direction. If the parent waits till 70 and gets a higher amount because they wait till 70, the parent gets a higher amount every month. The child doesn't. They still get 50% of the old full retirement age 67 amount. Okay. Now, and they also go to the highest parent's work record. So if the first parent who takes Social Security retirement, if they have a smaller record than the second parent who takes Social Security retirement, they will switch records after the second parent takes Social Security retirement. They'll switch from the first parent to the higher record. Okay, they can't be on both at the same time, but they will always be in the highest work record that they can be. Okay. All right. Also, if there's a divorce situation or a remarriage, or whatever the scenario is, if there's a step parent, in many cases, the child can actually go on the step parent's Social Security record. So we have situations where either the biological parent or the step parent, or we have like 3 potential records, sometimes 4 records they can potentially go on. Also, sometimes if a grandparent, if they lived with that grandparent, it's a little harder to do that one. But sometimes it's like of the 4 grandparents or the 4 parents, let's say step parents and biological parents, whichever is the highest record is the one they get to go on. Okay, so it's kind of a little bit complicated, but it could be a lot of money. And when the parent passes on, it goes up to 75% of the primary insurance amount. So it could easily be over $3,000 a month. Okay, if they had a max record. And if they didn't get Medicare yet, they got Medicare 2 years later. So my brother got SSDI on my father's record. My father took Social Security retirement at age 66 and however many months, which is what his full retirement age was at that time. And that meant my brother got Social Security on my father's record, and he got his Medicare card 2 years later. All right, and then he has Medicare the rest of his life. SSDI and Medicare don't care about assets, but of course we have to worry about assets to get into the system with SSI, and because we'll talk about Medicaid in a minute. Quick note here. My brother lives in a group home, as I mentioned. It's called a CILA, Community Integrated Living Arrangement. Because he lives in a group home, he's only allowed to keep $100 of his Social Security check. People are more familiar with this with nursing homes, right? They take away your Social Security check. So even though he's getting, I don't know, $2,000 a month on my father's Social Security record, he only gets $100 a month to keep. The rest goes to supplement his Medicaid rate. If we talk about an ICFDD, that's a campus, like Misericordia or Lamb's Farm, most famously, the largest ones in Illinois. There's plenty of other ones, though, run by Clearbrook even runs ICFDDs. Annixter, I believe, runs ICFDDs. So regardless, they get a smaller one, $60 a month. That's all they're allowed to keep. All right. Now, Medicaid, though, is so crucial because Medicaid is what pays for, it's much more than medical, it's what pays for my brother's group home. It pays for his job coach, his day program, everything basically post-school. It's also a backup health insurance plan. I really try to avoid having Medicaid be primary health insurance if I can help it, but for our clients, but it's fine as a secondary or even tertiary level insurance. You can have private health insurance, Medicare and Medicaid. Okay, they just figure out who's paying first, second, third. Medicaid's always the last to pay. For doctors, they may not take Medicaid. Specialists, therapists won't take Medicaid, but hospitals and pharmacies basically have to. So Medicaid becomes a free supplemental insurance that picks up the out-of-pocket expense that parents would ordinarily have for maybe an expensive prescription medication or hospitalization. Now, there's different kinds of Medicaid, and I want to bring this up because it gets very confusing for our clients because Illinois wants it to be, unfortunately. They have an incentive for it to be. So when people apply for Medicaid at 18, they try to put everyone into ACA, or Affordable Care Act Medicaid, based on the child's income being under $1,800 a month. The problem is the definition of income under the ACA or Obamacare Medicaid is based on a different type of income called MAGI, Modified Adjusted Gross Income. And that type of income will count the parent's income if the parents claim the child is dependent on their tax return, which is very often the case. So what happens is that the child at 18 will not qualify under ACA Medicaid. And what do they tell families? Oh, you don't qualify for Medicaid, period. But it's not true. They don't want you to know, sadly, that you could qualify for traditional Medicaid because if it's traditional Medicaid, they pay for half of the cost, the state of Illinois does. If it's ACA Medicaid, they actually pay 90%. It's not 100% anymore. They got rid of that. But 90% of the cost comes from the feds if it's ACA Medicaid. So they want everyone to be in ACA Medicaid. They do not want people to even know that they can be on traditional Medicaid called AABD, Aid for the Age Blind Disabled Medicaid, which allows them to have the income limit has nothing to do with the parents, even if they claim the child is a dependent. So there. The asset limit for Medicaid, traditional Medicaid in Illinois is 70,500. They actually increased that for the first time in decades. It was 2,000 forever. They increased it very recently to 17,500. They have a different income limit, but that's like a spend down income limit, and that gets kind of complicated how they apply it. But again, the key thing is the asset limit. Of course, you have a $2,000 asset limit for SSI. So while you're on SSI and have your Medicaid at 18, you're going to have a $2,000 asset limit. But once you get to SSDI and Medicare, then we only have to worry about the $70,500 asset limit. All right. There's also a different side door to Medicaid if this person's going to be working substantially. All right. Also, Part B, Part D premiums for Medicare can be covered by their Medicaid, by their Medicaid funding. So, all right. Health insurance. Generally, people know the rule that if your child turns 26, or once after age 26, I should say, they're cut off of the parent's health insurance plan. They got to figure out their own health insurance, right? People know about that pretty much. But Illinois has a unique law. It goes back to the 1960s, and it says that a child can stay on a parent's health insurance forever, not just till 26. This is really, really big deal for our families, because in other states, their kids are on Medicaid at 26, and they don't have much of an option. In Illinois, they can stay on the parent's health insurance for as long as they have it, which often lets us bridge the gap between being on a parent's health insurance plan and getting to Medicare, so they never have Medicaid as their only health insurance. If you want more information about this topic, information request form item number 4. All right. The state of Illinois Department of Human Services has different divisions that serve people with disabilities. Okay. There's Division of Developmental Disabilities, Division of Mental Health, Division of Rehab Services, also a Children's Division. But for everyone here, basically, DDD is the main division. However, DRS is often a agency you're going to have some interaction with. So DRS has the contract with school districts to provide transition services. So if your child is in a transition program, 18 to 22, it's almost certain that they're going to work with a caseworker from DRS. It used to be called DOORS. So job coaches, all that from DRS. But the main division for almost everyone here is going to be DDD in the long run. Okay. So what are the requirements to be qualified to receive services from the Division of Developmental Disabilities? Okay. The easiest way to qualify is to have an IQ test on a test given before age 18. Well, the thing not before 17 is another thing kind of related back to SSI I'll mention in a second. But the key is before age 18, have an IQ test of 70 or below. So I tell families in the age group that we're talking about here is, as soon as possible, next 3-year eval, whatever it is, get an IQ test. Just get it documented, get it in the books. Because if we have a documented IQ test that's 70 or below from before age 18, we have a much easier time with puns in the Division of Developmental Disabilities than if we don't. So I just want to get it in the book so we don't have to even think about it anymore. Okay. Now, when they are 17, we actually have to get a different test. We have to get the adult test, and it's a specific test that SSI likes called the WAIS, the Wechsler Adult Intelligence Score. So that we need to get there. But that's until 17. For right now, just get Vineland is actually the preferred test that DDD likes, the Vineland. But they'll even take a WISC, which is a more common test that's given. So whatever it is, just make sure that they do that. And by the way, you can still see in the old language, the federal regs still use MR, and it's like they still haven't updated that language. It's ridiculous. But regardless, so that's the 70 or below IQ test from 4 to 18. If they don't have that, if we had someone who's maybe, we have clients certainly who have children who have genius level IQs, but they have very substantial functional limitations otherwise. And so they could qualify for the related condition test. Also, people with CP and epilepsy, if they have other things that cause them to have these issues of adaptive behavior, general intellectual functioning that can cause them to have these issues, they can still qualify. So there they look to substantial functional limitations in 3 or 6 major life activities, like if they need prompting for self-care, if they have struggles with learning, language, written and verbal communication skills, executive functioning skills, and independent living skills, okay? So a lot of times, even if they don't qualify as having this IQ 70 or below, they qualify under this test. But I always prefer to get, if we can do it, if we can get a 70 or below IQ from 4 age 18, I like to have that in my back pocket because that makes it a lot easier of a road, okay, to qualify. All right. So everyone at this point, because I think everyone's over 2.5 at this point of the group here, everyone should be in the puns. Everyone's kid should be in the puns, okay? Stands for prioritization of urgency for services. It's required if you want any services from the Division of Developmental Disabilities, and you can get in there starting at age 2.5. Now, Medicaid, as I mentioned, is what pays for my brother's group home, but puns is how you got selected for that group home, okay? So you got to be in the puns, and you have to have Medicaid as an adult, okay? Now, when it comes to as a minor, you don't. By the way, if you get selected for services as a minor, we'll talk about the children's waiver in a second more. They'll give you Medicaid automatically at that point. You don't have to apply for Medicaid yourself. But as an adult, you need adult Medicaid for puns to fund you. But everything basically when school is done is funded by Medicaid, and the puns is how you get selected for it. So we have the children's waiver. The only thing basically available other than respite for children under 18, or the MFTD waiver, medically fragile technology dependent waiver, for a very specific group of people, of children. Other than that, the children's waiver is the only game in town. It's something you can get only through the puns, okay? Through the Division of Disabilities. It's an allocation of 2 times the current SSI amount, so currently $1934 a year. It comes along with Medicaid, even if the family would never qualify normally. It automatically gives you Medicaid as a free backup to private insurance. And it's allocation to pay for private therapies, program services, or even just like a respite. So it can even be paid like to a grandparent to help with your child or whatever, so someone can be compensated. So that's what that is. The adult version of the children's waiver is more money, $2,900 a month in today's dollars, and it can be paid to a parent income tax free if it's provided in their own home. Okay. This is only once they are done with school though, that higher amount. Now let's talk about children's waiver for a second. The children's waiver, it used to be like a third of people were selected by lottery, 2/3 were crisis. That's changed over the years. Then they had random pun selections for children's waiver by lottery. They did it in 2022 and again in 2023. They have not done it for 2 years now. 2024, 2025. They did not, they did it in 2022, 2023. They did not do it in 2024, and they have announced they're not going to do it this year again. So for 2 straight years now, we're not going to have a pun selection by a lottery for children's waiver. However, if you qualify under the crisis criteria, you can still get it. So what I tell families is, don't wait. If you're in crisis, talk to your caseworker at your ISC agency for PUN, and make sure that they submit the packet to Springfield to get crisis funding. Classically, this can happen, especially when you're talking to people on the autism spectrum. This will often happen during puberty. Behaviors can get out of hand, and so they can be deemed a crisis. Don't wait. Don't sugarcoat it. Tell them, like it is. Talk to them. Talk about the worst days, the hardest days. If it's really challenging, if it's a point where it's really too much, really, for you guys to sustain, as well as maybe the siblings to sustain and be living with, push to get this money so that you can have more respite, more support. People just don't think about it. They don't even think. I've had so many clients who it's like it happened 3 years ago when they really were in crisis. They got through it, but they would have qualified for sure, and it could have helped a little bit. So definitely be aware of that. If you're in the puns, you have to go call your caseworker and say, hey, I think we should be deemed a crisis now because of what's going on, so you can get that funding. Once you have the children's waiver, they don't take it away from you. And it goes all the way until 18, and at 18, it gets rolled over into the adult waiver, so you automatically now have the adult waiver. There's no gap. Now, for everyone else, which is the vast majority of people who never get crisis criteria for children's waiver, never get the children's waiver under 18, they're in a different category, which is they get part of the waiting list starting at 18. So it's very, very important that you're in the puns listed as seeking services, okay? In the puns listed as seeking services, so that you're eligible to be part of the LIGIS class, a LIGIS class member, part of the LIGIS consent decree. It's a lawsuit. The state was sued and lost. And so here's how it works. Under federal court order, Illinois has agreed to fully fund for services for people with IDD within 5 years of becoming a class member, which means 5 years from their 18th birthday. They have testified in the last few months that they are serving people within 44 months of turning 18, so less than 4 years now. So I would hold their feet to the fire. I tell families again, this for older, if you have friends who have older kids, don't let them play games. Oh, we have up to 5 years. You told the federal judge that you're doing it within 44 months because you're trying to convince the judge you're doing such a great job. You do it then. All right. So, anyways, basically, before what's really amazing about this whole consent decree, one of the things that's amazing about it is it's closing that gap. There used to be the so-called cliff. Children aged out of special ed services at 22, and there was nothing for them for years. That has changed, thank God, because of two things. Number one, during the pandemic, they changed the law so that the child gets to finish the school year in which they turn 22. They no longer have the bus stop coming the day before their birthday, which is ridiculous. In addition, we have this other consent decree that says that basically within now 44 months, within 4 years of them turning 18, they're going to get their services, which means that they should be funded clearly in all cases before they age out of special ed services. That's a really big deal to avoid that cliff. So then at minimum, they get this home base instead of once their special ed services end, they get home base worth about $35,000 a year. Again, paid income tax free to the parents potentially, could be used to pay for day programs, job coach, support employment, etc. Okay. But then we look at residential, okay? Because in the long run, living with mom and dad for the rest of their life may sound good. It may actually be hypothetically in their best interest while their mom and dad are still capable of taking care of them, but it is not a good long-term plan, right? Because in the long run, mom and dad are very likely they're going to outlive mom and dad, or certainly get to the point where mom and dad can't care for them anymore. And now we have a crisis, and we want to avoid a crisis, right? We want to make sure that whatever their long-term living situation and support situation is done in a really thoughtful and planned out manner over years, not in a matter of a week or two while we're in crisis because of a health issue or because the parents have passed. So because of that, we want to make sure that we're in place and we're looking at residential options. There are also some organizations that were very hesitant to take anyone who's over the age of 30 or even 35 sometimes as a cutoff. So again, we want to think about residential early rather than later, and make sure that we're making a really good choice and we're having the time to really investigate and look at these options and not just kind of ignore it basically. So that said, what is the state paying for residential? Anywhere from about $80,000 a year to, in some cases, hundreds of thousands of dollars a year, 300,000, 400,000. There's actually one case of $500,000 per year. Now that's obviously an extreme case. My brother's rate though is about $140,000 a year, and he has one-on-one funding for part of his day because of his behaviors, etc. So it's a huge cost. It's something that even very families that have very significant financial resources still need to have available. Okay. That rate includes supported employment or job coaches, includes day programs, etc. When we talk about ICFTDs, these are the campuses like Misericordia, again, or Lamb's Farm. Their average rates are even higher. Their average rates approach $200,000 per person per year. Again, parents' house income doesn't count for this. Now, how do you get in the PUNs? If you're not already in the PUNs, you got to call your ISC, your Independent Service Coordination Agency. Okay, is everyone within the city limits here, or where are people? Are they all in Cook County?
Yes, I believe they're all in Cook County.
All right. Are they all in Northern Cook County or some of them in Southern Cook?
I think most of us are in the northern part of it.
All right. So north of Madison, on a line going north of the zero right street in down Chicago, north of that dividing line, all the way to the DuPage County border, that side so the whole northern half of Cook County, divided by the middle of the city of Chicago, is CAU, Community Alternative Limited. They're at 773-867-4000. Okay, that's the ISC agency for seems like all of you. If you happen to be south of Madison, it would be, depending on where you are, then it changes. If you're in the city, it's CSO, Community Service Options. If you're in the suburbs, it would be Suburban Access. But again, it seems like for almost everyone in CAU, because you're either north side of Chicago or northwest suburban Cook, you would be CAU's area. All right, so given that's who you're dealing with, your ISC agency, you can always, of course, ask at the end if that's not the case for you. There is also another program out there. Once they're 18, and you're waiting the 4 years or so to get them their PUNS money, the home-based, you can actually get them, it's a stopgap measure, you can get them money through DRS. They have something called a DON score, determination of need. Once they're over 18, they're eligible for, and you can get basically, 20 hours a week of personal assistant hours at $18 an hour, paid to the parent, once again, income tax free. So we have a lot of clients who are getting like $1,000 a month from DRS to basically take care of their child as they would anyways, but now the state is covering it because, hey, they're not obligated to anymore. It's just a maybe more obligation, but not a legal obligation. And so the state's helping cover that extra support that they're having to provide for their 18-year-old child. So that's money to help bridge the gap between the 18 and 22. Of course, at 18, they should start getting SSI as well, which will help. All right, so we know we can't leave money directly to someone who's going to be on government benefits, and we're not going to not have will allowance when forced, as half goes to spouse under Illinois law, half goes to the kids. If you're not married, then it all goes to the kids directly. We're not going to disinherit the child and leave everything to the other kids and cross our fingers they'll take care of them, because even if they're very honest, trustworthy, financially savvy people, and they're old enough to handle all this, doesn't mean that, or maybe do an aunt or uncle or something that we give this money to, it's more obligation. It doesn't mean that they won't have their own things beyond their control, like IRS creditor divorce. They die and they leave their money somewhere else in the inheritance, and now what, right? And they have the people who receive that inheritance, they understand there was a moral obligation to use that money for someone else. So we don't want to leave money as a moral obligation to other kids. We want to leave the money in a special directed trust for the child, called a special needs, not a traditional trust, but rather a special needs trust. There are two kinds of special needs trusts. Third-party special interest for gifts and inheritances. Okay, that's the main kind of trust we want to set up. There's another kind of special needs trust out there called a self-settled OBRA first-party or payback trust. It's not as friendly. Okay, so we use it when we have to because someone messes up, and we'll talk about that. What both types of special interests have in common is they're reserve funds over and above government benefits. There is no limit to how much money can be in a special needs trust. Okay, there could be millions of dollars in a special needs trust, and it won't impact government benefit eligibility whatsoever as long as the trust was drafted right. So it's been around since 82 by court decision, 91 by Illinois statute. So it looks like this: inheritances, gifts, life insurance, retirement account, beneficial designations. But never, ever do we want the child's money to go into this trust. So really important to remember, the child's money never goes into this trust under any circumstances. Okay, if we take the child's money and put it in this trust, it'll taint the trust and make it a resource. So never do that. Okay, it's very important. Remember that? All right. Now, the note about retirement accounts, there's actually a special tax benefit when a beneficiary of the special trust is an IRA or 401k or IRA, leaves a beneficiary's name the special needs trust. It gets to stretch the so-called RMDs, or criminal distributions, over the child's life expectancy, whereas when it's left to other kids, they only have 10 years to take the money out. So there's actually a tax benefit there. When the child passes, the trust says what happens, right? Does it go to the other kids or the nieces and nephews of that child, the grandchildren of the parents, or other places? That trust, with the trust document, says what happens to it. So the special needs trust should not be in the parent's will or the parent's revocable living trust for a lot of reasons, because we want to exist now, not only when both parents pass. For one reason, piggybacking. This is an important one for people who have young children, right? Which is this. Grandparents, so parents might say, you know what, statistically speaking, it's a good chance at least, God willing, we'll both be around, but at least one of us will be around. But grandparents at some point are going to pass on, and it could happen, sooner rather than later. So we want to make sure that they don't mess things up in their estate plan. I can't tell you how many times grandparents have thought they're doing such a nice thing and left money directly to the child with disabilities or in a bad trust to the child with disabilities. So we want to get the trust to exist so that we can say, hey, grandma and grandpa, here's the language to add a paragraph onto your existing documents. We call that piggybacking. That grandma and grandpa can piggyback onto the estate plan. Same thing with if it's an aunt or uncle, they can piggyback onto the estate plan, the special needs trust, I should say, of the child that was set by the parents. If laws will change you to be grandfather, the trust has to exist for that purpose. Under existing laws, rules of change are made. To be grandfather, the trust has to exist. This is really important. What if, God forbid, a grandparent needs skilled nursing care? If we establish a special trust now, in the years ahead, a grandparent needs to go to a nursing home, and let's say they have $800,000 of assets, their home and other stuff. They have some money, but they're not, they don't have millions. They could easily wipe out all those assets paying for skilled nursing care, $8,000, $9,000 a month, okay? Or it could be more. So if that's a scenario, the general was going to just give your money away and have the state pay for you a 5-year look-back period if you try to give your money away to your family, right? But they created a federally permitted transfer, federally permitted exception to this rule, which is that gifts can be made to the special needs trust. So if, let's say, grandma needs good nursing care, she can gift her money into her grandchild's special needs trust, and the next day it would qualify her for Medicaid to fund her nursing care. Now, Congress created this exception because they felt that it was like, for good public policy reasons, will let people gift to a special needs trust for someone who's disabled. Okay, but we can't gift to anyone else, right? So it's only to a special trust for someone who's disabled that this works. Okay, but if the alternative is they're going to spend all their money, this is a much better situation because now the money is protected and it's going to be preserved in the future. All right, so we're talking about third-party trust. What if someone messed up, right? What if we have a grandparent or an aunt or uncle or the parents who messed things up and left money directly to the child, okay? Or what if there's money in their name and they're over 18? Well, the good news is, or over 15, we're in the look-back period. The good news is everyone here is pretty much young enough that they'll probably clean up that mess beforehand. A note about 529 college savings plans. If you're lucky enough to have a grandparent or grandparents who have significant resources and they want to make gifts to the grandkids, they can't gift to their grandchild with disabilities because it'll mess up their government benefits in the future. But what they can do is gift to a 529 college savings plan. Even if there is virtually no chance they'll ever go to a accredited college program, the 529 plan is actually a really flexible thing. So if they're disabled, then after 18, we can use the 529 college savings plan for anything, literally a vacation for that child, and it would qualify as permitted without any penalty. They could tax you on the growth, but the way that taxes work, we can avoid the taxes to a very large extent because it's taxed at the child's tax return level, not the parents. Also, we could use things called an ABLE account to transfer some of the money to use it also tax-free, penalty-free there. So the bottom line is, if grandparents want to gift money, 529 plans are the place to do it. Not to a UTMA account, not to savings bonds, not to anything else. Okay, not even to the special needs trust if they have an estate tax issue or gift tax issue. So all right, ABLE accounts. $90,000 limit per year. So ABLE accounts are created by Congress to be something akin to a 529 college savings plan, but for people with disabilities. That said, they're capped at $90,000 per year. All right. Okay, but it's increased by work earnings. Okay, fine. If they're under 18, the parents are in charge. When they turn 18, they become in charge, unless the parents become guardian for the child after 18, in which case they kind of revert back to the parents being in charge. The balance is going to be over $100,000. Limitations how to spend it. The government came out with regs. The IRS came out with regulations that said we don't really care what you do with it. Just don't give it away. As long as it's for the benefit of the child, we won't question the expenditure. Is basically what they said. But there is a potential payback to the state when the child passes. So I do not want parents putting $19,000 a year into the ABLE account. Okay, that doesn't make any sense because there's a potential payback when the child passes to the state for Medicaid's fund during their lifetime, could easily be everything that's in that ABLE account. So what I tell families is this: if you have a purpose for it to use the ABLE account, then great. For example, let's say you're paying for special rec, okay, or some other expense, a special camp they're going to be doing, HIPAA therapy, whatever it is. You have an out-of-pocket expense. You could, if you want, get a 5% discount, so to speak, by filtering through ABLE. You open up an ABLE account, you put the money in the ABLE account, you take it right back out. You just got you got a state income tax deduction for that up to the $19,000, right? So it's something you can get some money back. Less than it is like we're talking about less than $1,000 here, even if you do the full 19. But it's something, okay? So okay, fine. When we use ABLE, they have excess Social Security work earnings. That's down the road. Short-term savings, again, what I talked about already. Beneficiaries get just in spending money. If grandparents left $5,000 or $10,000 to them, if it's not a large sum, ABLE account could be useful. Court-ordered divorce in a divorce court or child support. I don't really love doing it with this because this is a very flimsy option because the Chicago region says you can do it, but no other region says you can. And President Trump says he's going to change this anyways. He's going to get rid of the regions or something. So I don't want to rely on that using ABLE for divorce, court or child support from a divorce situation. But like I had mentioned with that whole gifting thing, the 529 plan could be converted to ABLE up to $90,000 limit each year. So it can be a useful tool when you use it in conjunction with 529 plan, the ABLE account. All right. Now, the first party trust, okay, is the other kind of special interest that's been around since the early to mid 90s. And it looks like this. Okay, well, first of all, it's a lot of names for it: self-settled, Ober, first party, D4A, payback trust. So it's kind of confusing because you hear it referred to in different names. But the bottom line is this kind of trust, not as friendly. So inheritance of gifts not collected after third party trust. Personal injury medical malpractice settlements. Quick note on that. If someone, part of the reason, maybe CP or otherwise, was there was complications at birth or in utero or things that were missed, there's a lot of people think that if you don't sue within the first few years, that the statute of limitations is over, you can't sue anymore. Illinois actually is a very permissive statute of limitations, and it says if someone has cognitive disabilities, the statute of limitations is told indefinitely. So you can sue at 20, at 18, at 20, or whatever, if there was something that was done wrong at birth or around birth. So just something to be aware of. And if obviously if you want, if that is ever the case for anyone or somebody you know, you're certainly there's people I can certainly refer you to that actually do nothing but medical malpractice birth injury cases. They don't do car accidents and other things, so that you can get an expert who can really review that case. But anyways, in those cases, if there's a settlement and there's something the part that goes to the child, and again, from the beginning, we would try to make sure that most of it, or a good chunk of it, goes to the parents. We don't have this issue, but for the part that has to go to the child, it's actually gonna have to go to the first party special needs trust, which is the same place that inheritance of gifts that are not correctly left, third party trusts have to go. So this is where we tell grandparents, hey, if you don't listen to me and you don't fix the documents and make sure that the trust, the special interest we set up is the beneficiary, even contingently, but it still could name your grandchild with disabilities, it's going to have to go to this kind of trust, which means that when the child passes, the government's going to grab the money basically no matter what. Okay. This, by the way, is also the trust that child support, court of child support generally has to go into, because ABLE's not a great place because of the worries about whether it really qualifies or not. So again, this is a tool we use, this trust, for medical malpractice, personal injury settlements, that where grandma, grandpa messes things up, or for court of child support. All right. This talks about court of child support. There's a lot of stuff in special needs divorce situations that you need to think about. Health insurance can go past 26, so we can actually have in the MSA requirement that the parent keep the child on the health insurance plan past age 26. Life insurance can be maintained not just until the child is an adult or through college. It could be a permanent life insurance policy is required by the court. These are all unique things when there's a child with special needs. It doesn't usually happen. So you should just be aware there's all kinds of special stuff with that. And if you want more information about that, item number 3 on the information request form. All right, so if someone here has a special interest already, okay, or doesn't, but which is maybe for most of you, you have to submit it if you have a trust that's actually created and funded technically, you have to submit it to Social Security, SI, and Medicaid either when you apply for benefits or once it's established, after it's been established and funded, within 10 days. All right. So the question is, will it qualify? Okay. Well, there's a lot of mistakes we see in special need trusts that can cause it not to be qualified. One is it won't be 100% discretionary. It'll say that the trust can be used for this, not for this, only use up to this amount for this. You can't do that in a special needs trust. Okay. It's not going to be giving cash directly to the child. It has to be spent for their benefit. You could pay any expense for them, but it can't give them cash directly. If someone's more independent, we could use ABLE accounts for that kind of purpose, but we can't give them cash directly. It should not be directed overly restrictive. It should be able to be used for the most basic living expenses, all the way through to vacations, etc. Often trusts will be drafted because they don't really understand the laws, rules, and Medicaid regs and Social Security forms enough, and so they draft for the most restrictive possible to protect all benefits. But for many families, we want the trust to be able to be flexible and say, hey, if it's in the best interest of the beneficiary, be willing to take a 1/3 reduction of the SSI. And hey, by the way, when this trust is funded significantly by the parents, the child's going to be an SSDI, not SSI, and we don't even care about that silly housing rule. So we want to not be overly restrictive with the trust. Okay, another mistake we see is failure to include contribution language or gift language. What do we mean here? The ability to make charitable contributions to organizations providing services to the child, or that may in the future provide services to them. Why? There is a 20-year waiting list for this fantastic organization in terms of residential. It's amazing how you write a check and there's no waiting list. Okay, if there's the ability, let's say mom and dad are gone and there's $500,000 or $1 million or whatever it's in there, 200,000, whatever's in this trust, within the means of that trust, we can write a meaningful contribution, it's possible that that might be enough to convince them to put you to make it work or whatever. Um, okay, number one. Number two, we want to make sure we're buying goodwill and influence. We are maintaining influence with the agency, with the leadership, that they know that this family or the trust, for the special needs trust, the trustees of it, we should keep them happy. So if there's a concern, if there's a worry about the person that there's a not a good dynamic with the new person that moved into the group home, or there's a concern about this new staff or whatever it is, that they're going to listen to us. They're going to respond to our calls faster than they ordinarily would. Should it work that way? Of course not. It should go without saying it shouldn't work that way. But this is the real world here. Okay, if we have the ability to make charitable contributions, and it doesn't take that much, honestly, to make a difference. So if we have the ability to make charitable contributions, we want to be able to do that. Maybe it's because we want a bathroom or a kitchen that needs to be remodeled or whatever. We want it to happen faster and not waiting till the timetable the agency has. The trustee can make a contribution to make it happen. Gift language. Another thing we do is before we get off of contributions is if we want a specific setup, like we want a limited number of we want there to not be more than 2 other people in the group home. Well, Medicaid rates as they are probably doesn't make sense for the agency to run a 3-person group home. But if there's financial contributions, charitable contributions, they can usually make the budget work for the house, right? So if the parents are gone, the trust can keep doing that after the parents are gone. And they can buy a table at the annual dinner and all these other things. All right, gift language. We want gifts maybe coming from the child to their niece for their niece and nephew's birthday party, but that's a small little thing. We're talking bigger picture though. We want gifts for support staff. It's Christmas time. We want to give $1,000 in Target gift cards to each of the support staff so they know how much we appreciate them. And we're influencing them too, that we know that they're going to tell us if something's going on before we even have to talk to the Q, the first level management of the group home, or even beyond that, the VP. So we want to influence and buy goodwill, for lack of an expression, show appreciation to the agency. So we get goodwill with the VPs and the higher ups, and we want to get goodwill with the direct support staff, DSPs, through giving really generous presents at Christmas time, etc. Okay. So this is all the things we want to have in the trust. If we don't have it in there, we can't do it. What else? Nursing home empowerment exception. There's actually specific language that should be in the trust to make sure it qualifies for that. Public pensions. This is really important. If one of the parents has teachers' retirement system pension, state university retirement system pension, the military pension, downstate police pension, downstate fire pension, state employees' retirement system pension, judges' retirement system pension, all of these pensions can go to a special needs trust after the parent has died for the rest of the child's life. It's a huge benefit. Could be worth millions and millions of dollars, but if you don't dot your I's and cross your T's, it doesn't happen. And if you don't even know about it, it doesn't happen. So we have so many people who leave this on the table when their child could be getting $40,000, $50,000, some cases $80,000 a year for the rest of that child's life, and they don't even know they could have done that if they did things right. And there's a lot of stuff you have to do with your taxes, with how the beneficiary designation form is written, with the language in the trust itself, with a lot of stuff. So it's really important to do this planning ahead of time, because that benefit could be the biggest single source of funds for that special needs for the rest of that child's life if there is a public pension available. All right. What else? If they're moving states, because let's say that the siblings of all their sibling or siblings have all moved out of state, we can have the trust be modified as necessary to qualify for Medicaid in the new state they're moving to be closer to their family. We've seen that happen quite often where they move to be closer to the siblings. All right. The rest of the estate plan, the wills, the revocable living trust, we do living trust for larger estates, irrevocable life insurance trust, other gift trusts, irrevocable trusts. They have all kinds of language in the boilerplate documents created by other drafting estate planning attorneys that are a disaster for special needs planning. So you have to be very careful about how every single estate plan document, not just a special needs trust, is drafted. All right. If you want more information about being a trustee of special needs trust, I can give you, hold on a second. Excuse me. All right. So we can give you a handbook. I have to update the image there. We have one for 2025 now even. I just noticed that. But anyways, if you want that handbook, item number one in the information request form. If you want more information, just kind of review over the topics we talked about generally special needs planning. Item number six, information request form. And then finally, we have special needs trust and taxes. If you're having trouble falling asleep at night, we have a form. We have articles written about how taxes work with special needs trust. It gets kind of complicated. Okay. All right. This talks about writing a book about your child, writing a letter of intent, as it's often called. History, family medical history information, history of the diagnoses, hospitalizations, medications they've been on, never want them to be on again, doctors they currently see, as well as doctors they never want them to see. All of that information, history of it. If you're having a difficult time, what helps, what doesn't, has certain buzzwords with my brother. You won't go to sleep, you say this word. Who to talk to if they're having a meltdown, okay, what helps, what doesn't. Thoughts about the future with school and the IEP meetings. What's the latest? What's going on? What are we trying to push for? Maybe the school is reluctant about this, or we think this, or whatever the case is. They were tuitioned out here, and we want to make sure we maintain that. Last, your most recent thoughts about employment. What would be a good job that would be a good fit for them? They would enjoy, get some fulfillment out of activities they like to or don't like to do. Thoughts about that future living situation. What do we think? You think like they're very social, they really would like to have live with a lot of people, or no, I think more than two other people would be too much for them, etc. When someone's passed on, let's say a grandparent has passed on, how do they process that? How do they talk about it? How do they deal with death? Because if they're reading this, unfortunately, it's because the parents are presumably gone here. Last correspondence with SSI, Medicaid, puns, all that stuff should be written down so people can have access to it and review it. Where are the estate plan documents are? Where's the special need trust? Where are the estate plan, wills, revocable living trust, life insurance policy information? If the parents have set up plans for the funeral for that child, if they have a plot, like my parents, they told me many times now, they give me information about that they have a plot they bought next to them where my brother's supposed to be buried. Write this stuff down because people don't want to talk about it. And so it's helpful to have that all written down. And then the executive summary. How do you get the next 24, 48 hours with that child? What is the stuff they got to know? They have this big book that's 50 pages long. What's the basic stuff you got to know? Here's a cheat sheet. This is really important, not only for the future care team, it's also important if they're going to live residentially down the road, so that new staff come in, they can review this before they even ever start working with your child. So that can really become helpful there. And if you want, we have an information request form item number 2. We can give you a fillable PDF form of this. You can as well as articles talking about this topic of letter of intent. So you can use this as a guide to filling out a letter of intent document. Okay. All right. I want to open up for questions. I can talk about like guardianship and stuff, but I cut that out purposely because of the ages that of the families here. If people are 16, 17, I'd really want to talk about guardianship. Just a quick note about guardianship is that basically so quick note guardianship number 1 is at 18 everything changes. You lose all rights to make all decisions for them. So just be aware of that. Again, that's probably as much as you need to know. And when their kid is 4 to 8, 9 years old. So if you there's someone on here who doesn't fit that category, we can talk about it more. But basically at 18 everything changes, and you're gonna have to do something basically to be able to make some decisions for them or all decisions for them. All right, with that, I wanted to open it up for questions that people might have, concerns, thoughts about either their child or planning in general, or questions about benefits, etc.
Hi,
Hello,
I'm Emily. Nice to meet you.
nice to meet you.
So I had a question. We have an 8-year-old diagnosed with autism at 2.5. And at 2.5, if you had asked me where we would be at 8, I would say something very different than where we are now. He's exceeded all of our wildest dreams, and we're super excited. But he's 8, and there's still ways in which he has lots of challenges. I'm wondering, in terms of when you work with a family to do special needs estate planning, does it how does like the child's level of being able to function independently, other things, How much does that play into your plan?
Mhm.
And is it something where for, I'm sure I'm not alone here, but like for parents of kiddos with autism, like it just really changes and they kind of develop at their own pace and it's hard to know, where they're going to end up. I could
Right.
see my kiddo needing, to live in a group home with lots of support. I could see him living independently with
Mhm.
very little support and working
Mhm.
full time.
Yeah.
So just curious if you could speak to that a little bit.
Of course, absolutely. It's not sort of far from uncommon, as you alluded to, situation. So, a couple things. Number one, yeah, we don't know, right? Jerry saw, we have no idea. We need to plan for the worst case, but be sure it's flexible to deal with, where they may be more independent. Continuum supports that they could be receiving under current, structure of support of systems in Illinois is everything from, 24, it's actually beyond this, but let's just say 24/7 group home, one-on-one funding in a 24/7 group home is actually kind of the most extreme, all the way to technically a state institution that's actually worse, but in terms of funding level. But let's just say one-on-one funding in a group home through to home base where they're getting 30, whatever, $35,000 a year to pay for supports. Okay, so that's kind of the continuum. 150,000, technically higher than 300,000, down to like 35,000 a year, and then Social Security is on top of that. All right, that's a continuum of support. Now, if they need, let's say that lower end, what does that look like? They need someone maybe just a few hours a week, maybe is the little least amount, right? They need someone a few hours a week. They're living in their own apartment. They work full time. They need someone a few hours a week. Even if they don't work full time, but they need someone a few hours a week. Otherwise, they can be pretty independent. They can't maintain a job, but they can be somewhat independent there. There's something called intermittent still, which falls in the middle, where staffs are intermittently. They're there usually a few hours a day in the morning and at night to help with like morning routine, breakfast, help with dinner, bed routine, and they say, all right, guys or girls, have a good night. We'll see you tomorrow, right? And then the weekends, maybe they show up for a couple hours, but that's it. So it's usually 15 to 20 hours a week total. That's it. And that is all. This is funded by Medicaid. All this would require special needs. All this would require all these things, right? Now, if they are at the other end where it's like they are working full time, which means they don't qualify for anything, okay, then yes, they could be at a point where we then just terminate the special needs trust and say, hey, they don't need special, just they'll get their money outright or in a normal trust till they're older and treat them like the other kids, so to speak. The issue we find out, unfortunately, is that we have to be careful on is that the government is not very flexible here. If you can work full time and make $40,000 a year, you are probably better off not doing it. Okay, if you can get these benefits and services, because they're worth way more than $40,000 a year in cash even. If you can make 80 or 90,000 a year or more, then yeah, it's worth it for you to work full time. But of course, if you ever fall off the horse and now you can't do it anymore, you're never going to be able to get back and get those benefits and services because you've proven the ability to earn too much money for too long. They're not going to be able to get you probably into the Division of Developmental Disabilities. They probably won't be able to get you Social Security and Parents Record anymore, et cetera, et cetera. So they lose out on all kinds of programs by just trying, unfortunately, and succeeding for too long. If they keep failing very quickly, it's okay. But if they succeed for too long, but then they fail, they're in a really bad situation. They don't have benefits and services, and they don't have anything. They don't have their work earnings. So now what, right? There are some programs, but they're way less generous. So that is a concern for a lot of our families. Is how do I balance all that? I want them to, to really strive to be as independent and do as much as they can do, but I also don't want to set them up for failure and that kind of scenario. So it is a conversation to have, and how do you balance all this? It's not easy. I would love the government to change the rules. There is something called the Work Without Worry Act that would help to some extent, but it has gone nowhere for like three cycles of Congress now. But as of now, it is kind of a conundrum. But when we talk about planning, we plan for the fact they're going to need some supports that are going to be funded by Medicaid waiver dollars. And we hope that maybe they're at the one end of that spectrum where they don't even need any of that and can really work full time and be totally separate, self-sufficient.
Thanks, I appreciate it.
Benji, going back to puns, I had a quick question because I'm more familiar with it being set up as the lottery and getting chosen and being the lucky ones. Could you repeat what you said, that it for this year and last year, it's not set up that way? It's mostly just for emergencies only.
Yeah, so the children's waiver is right now they just announced it. So there was an ARC. We have the big ARC conference coming up actually in Bloomington, but it was a League of seminar we spoke at. It was a mini conference, virtual one. This was 2 weeks ago, and the attorneys for Ligas said the children's waiver, and actually it was the director of the Division of Developability said in their presentation that they are currently not planning to do a pun's pull for this year for children's waiver, and they didn't do one for last year. They said they just don't have money, and so they're not doing it. So it's the only crisis right now for children's waiver, and the adult waiver, of course, is this whole waiting thing.
And then I have one more question, and I'm not sure if, this is on parents' minds, but I know for myself, not having a child that has disabilities, but feeling a concern for these families and the current government affair, not getting into politics of anything, but more so, are you able to share any, insights as to how things are going currently and how that may impact even future planning for the families that are, online right now?
Sure. A few things. Number one, obviously right now all the oxygen in the room is taken up by the tariff thing, so kind of all this discussions about Medicaid is kind of done fall on the wayside, but it will come back at some point because they want to get the tax cut passed, the Republican majority, and so they have to pay for it because there's conservative members of the party that will not allow them to pass the tax cuts without having spending cuts, and they're not going to cut Medicare, Social Security, so Medicaid's really the only other big program to cut. All right, so let's talk about it. The proposal in the House side, the Senate is currently saying like cuts to be determined. Basically, they're just kicking the can down the road. But the House side specifically talked about Medicaid, and the proposal they specifically discussed was that they were going to basically get rid of this match. Remember, I said that Illinois has an incentive to get everyone into ACA Medicaid because the federal government pays 90% of the cost. The big thing they said they were going to try to save money on is get rid of that and say it's back to 50-50. Now, of course, that means that the Illinois is probably going, could say, Governor Pritzker could say, all right, if that's the case, we're going to cut back on expanded Medicaid and no longer provide that to that group of people. And so they won't have expanded Medicaid anymore because it costs too much. We're back to pre-ACA. For our families, it doesn't really change anything. Okay, because for our families, they would qualify for an ABD Medicaid anyways, at least directly. Now, indirectly, what is some of the fears? Some of the fears is that Governor Pritzker says, wait a second, the families who are on expanded Medicaid, who qualify only because of ACA Medicaid, not because they're disabled, they vote. And the people on ABD Medicaid, they don't vote so much. So maybe I'm going to keep that program and I'm going to find more dollars for Medicaid by cutting funding for service of people with IDD. Hopefully they wouldn't do that. That's a very immoral decision, but okay. Number one. Number two, I think we have some protection here because of the lawsuit, because of Ligas. That if they start cutting funding, they're already not in compliance. They'll be even more not in compliance with Ligas, and therefore, because of their lack of funding, and therefore it's not going to really help them because now the courts are going to come down on them and say, hey, you gotta fix this. And I mean, there was a scenario, and the judges can be really threatening. There was a scenario where there was no budget, and so they tried to cut funding for people like literally group home funding, and then they try to play a game where they said, well, if you're a class member, we will fund you, but if you're not a class member, if you're like somebody who's older, who's never part of Ligas, we're not going to fund you. And the judge said, if you try that, I'm going to send you to jail, to the state treasurer, the state, so like literally you're going to be spending your night in jail. So obviously they fixed it, I have some confidence that because of the federal court, jurisdiction over this, that they won't get too far with any of this stuff. And hopefully just because it's immoral and whatever, for them to do that. So I guess my initial indication, it's not the end of the world, it's not the sky is falling, but are there risks? Absolutely. There was talk about getting rid of Medicaid waiver, and that's actually a whole nother discussion, honestly, kind of more of a technical policy discussion. In the 80s, it was originally, before Medicaid waiver became what it became, there was discussion of having a special federal line item for like IDD services that would cover group homes and things like that. I honestly think that might have been better because we wouldn't have been tied in with Medicaid waiver, which has, with Medicaid dollars. Because I think that as a line item for IDD, it would be a fairly bipartisan line item, whereas Medicaid tends to have more, it gets polarizing. So I do think that I prefer if in some ways, but that ship has sailed basically. But there was actually talk, interestingly, in the Republican conference of changing that again and going back to that. But that's a big change. I don't know that's ever going to happen. So I guess the short answer is there's a lot in flux. But what they're discussing so far is not direct cuts to our services, and in at least the federal level. And if the indirect cuts to Medicaid waiver or Medicaid dollars in general cause direct cuts to us through the state of Illinois, I think that the Ligas consent decree will protect. I am hopeful, have some significant hope that the courts will protect us on that.
Thank you for that.
Yeah, of course. There's a whole other thing about special education services and Department of Education, whole other ballgame that affects certainly these families that we're talking to here. And again, it's a lot in flux. I have heard good noises that they said that anything that would have been Department of Education, they're just going to shift to other places, but I don't know what that really looks like. So again, a lot in flux there. And the hope is that they're really going. They said like their intention is not supposedly to hurt people with disabilities, but we'll see, right? Let's see what really happens there. Any other questions?
I only have one final one, but I don't want to take up everybody else's time. If there is no more questions, maybe just a quick wrap up of like, what would be some good next steps after hearing this presentation, besides filling out the interest form and sending it out? Like one good takeaway that would be like, if I was in your shoes, this is what I would do next.
So big picture stuff, make sure they're in the puns, make sure they're listed as seeking services. Make sure that the grandparents know that they need to leave it to the special needs trust directly, not to the child. Even as a contingency, it's not supposed to go directly to grandchildren, but it could contingently go to grandchildren if the parent of that child, the child of this grandparent is not living. Make sure that that's covered in their documents, that it goes to the special needs trust. Don't let them create some testamentary special trust that the attorney that drafted their documents throws a paragraph in. Have them piggyback onto your special needs trust that you create for them. Get an IQ test, preferably a Vineland, so it's in their back pocket for puns, so it'll always be there. I think those are some big picture stuff to do right now. And if they have assets in their name, it would probably be a good thing if they didn't before the look back period starts.
That's a good summary. Does anybody else have any other questions that they would like to ask to Benji?
Thank you.
Of course. Pleasure.
Helpful, thank you.
Of course.
Stop the recording real quick.